Court calls case People versus Dwight Miller.
Ashley Lonnie for the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Miller, who approaches your. Mr. Miller, can you please state your name for the record?
Dwight Miller.
Thank you.
And Your Honor, my belief is that my client does want to set this for preliminary examination. However, I am uncertain. He and I have had some conversations, and frankly, I believe he wants to make some statements to the court. I advise him against it, but at this point, I think he wants to talk.
Welcome to a courtroom clash that blurs the line between protest and procedure. Today, we step inside the heated arraignment of People versus Dwight Miller, a case where the defendant boldly challenges the court's very right to exist. From a first second, Dwight isn't playing defense. He wants to talk. He's got an affidavit. He's got opinions. And he's got a major problem with jurisdiction. But the judge? She's not here for legal fantasy hour. This case raises a wild question. What happens when a defendant refuses to acknowledge the system judging him? We'll break down what resisting and obstructing actually means, how jurisdiction really works, and why Miller's arguments might feel familiar to anyone who's seen a sovereign citizen meltdown. Stay tuned, because this isn't just about guilt or innocence. It's about law versus ideology, and the law isn't backing down.
So we're understanding this is a criminal matter, right?
It is.
Okay, so basically, man, it stemmed from a falsality. All this whole thing, I was falsely arrested, something I never did. I got a sworn affidavit.
Sir, I'm sure your counsel has advised you. I'm going to advise you to not say anything else about the subject matter of the case.
Okay.
If you'd like it set for preliminary examination.
I want to challenge jurisdiction.
And here begins. Miller takes the floor against the advice of his attorney and dives straight into it. His opening line, that this case stemmed from a false arrest. Classic. He doesn't trust the system, and he's convinced he's the victim here. But let's pause. When you say you were falsely arrested, you better be ready to back it up with clear, admissible evidence. Because in a courtroom, feelings don't beat facts. The judge immediately senses where this is going and jumps in to stop him. What would you do if you were the judge here? Shut it down or let him speak.
You want to challenge jurisdiction
Yes.
of whom?
Y'all have a jurisdiction of a case that doesn't exist against me.
On what grounds?
What crime did I commit?
Pardon?
What crime did I commit?
To allege that you committed the crime.
I didn't
of
commit that crime.
resisting. If you want to interrupt me, I'll answer your question. But if you want to keep interrupting me, I'm not going to play that way. I'll answer your question.
Here comes the infamous line. Y'all have no jurisdiction over a case that doesn't exist. That a full-on challenge to court's authority. It's a phrase pulled straight out of the sovereign citizen playbook, a movement known for making these kind of arguments in legal settings. But jurisdiction isn't just a feeling. It's established by law. If the state alleges a crime, they have the right to prosecute. Miller's saying, what crime did I commit? And the judge calmly responds with the actual charge, resisting and obstructing a police officer. This isn't a game. And the judge? She's done playing.
You're accused of the crime of resisting and obstructing a police officer.
So we all aware that this never transpired, right?
I am not aware of that.
Okay.
Is that all you have to say?
Mm-hmm.
Watch the tone shift. The judge is cool but firm. If you want to keep interrupting me, I'm not going to play that way. Translation? This is my courtroom, and you are not in control. Her delivery is professional, but don't mistake it for weakness. She's reminding everyone, including Miller, that authority here doesn't bend to conspiracy theories or courtroom grandstanding. The charge may seem minor, resisting and obstructing, but that's still a crime. And judges don't take lightly to disrespect or delay tactics. Have you ever seen a judge get pulled into courtroom drama like this? Drop your thoughts below.
Yes, sir.
So, Your Honor, I would ask Mr. Miller, Mr. Miller, I'm not submitting frivolous motions.
Can I get my affidavit put in on the record, please?
Affidavit.
My affidavit of the incident that transpired,
Your affidavit of what?
the facts in the case. My statement of what happened, can I get it on the record?
There will be an opportunity if you so choose, if this goes to a further proceeding, for you to put whatever evidence you want into the court. But this is not the time to do that.
Really? So when is the time to put that?
Now Miller pivots. He wants his affidavit read into the record. But again, he's out of step with procedure. In court, there's a time and place for everything. And tossing unsolicited statements onto the record in open court isn't how it works. The judge patiently explains. He'll have a chance if and when the case moves forward. This is not that moment. But Miller's confusion highlights something big. A total misunderstanding of how evidence is entered into a legal proceeding. Question for you all. Should defendants be better educated on courtroom procedure? Or is it the lawyer's job to keep them in line?
Evidence in there.
If you want it set for a preliminary examination, you'll have that opportunity. And if it proceeds to trial, you'll also have that opportunity.
So once again, I'll ask, do you want to set this for preliminary examination, Mr. Miller?
Sure.
Thank you.
Not really.
See, do you want to set it for prelim or do you want an adjournment?
Preliminary examination.
Thank you.
To your knowledge, all discoveries.
To my knowledge, yes, Your Honor.
People have their witnesses available the 24th.
Yes.
Even with all the interruptions, Judge remains professional and composed. She doesn't escalate, doesn't get personal. She just resets the rules. Her goal? Maintain control without adding fuel to Miller's fire. It's a lesson in courtroom decorum. And it's a reminder, a calm judge can do more damage than an angry one. This case might feel chaotic, but there's a system in place. Judges are trained to filter noise from the facts. And here, she does it flawlessly. Ever seen a defendant try to hijack a courtroom before? Tell us what happened.
Will be set June 24th, 2025, 9 a.m. That is before Judge Washington.
Finally, after all the back and forth, the court gets down to business. A preliminary examination is scheduled for June 24th, 2025. It'll be in person, under a different judge. This isn't a dismissal. This isn't over. It's a delay, one that gives both sides time to prepare. Miller wanted to challenge the whole system, but the system just kept moving forward. And that's how court really works. No matter how loud you get or how many affidavits you write, procedure always wins. Stick around, because when that prelim hearing comes, things could get even messier.
Thank you, Your Honor.
Thank you.
You want to get the discovery? They will have that ready too. I will make sure that.
So what did we just witness? A man convinced the system is broken, facing off against a judge who won't budge an inch. This wasn't just legal strategy. It was legal theater. Miller came in ready to fight the charge in the system. But courtroom rules aren't optional, and legal drama doesn't beat cold, hard procedure. As we wait for that June 24th hearing, the real question is, will Miller play by the rules or double down? What do you think? Will he come back prepared? Or dig a deeper hole? Let us know in the comments. And if you found this case as wild as we did, smash that like button, share your thoughts below, and subscribe for more jaw-dropping courtroom breakdowns. We're just getting started.